With that, I am very pleased to introduce our first panel of the day, the law of secrecy. And I should say, if you didn't notice it as you were coming in, if you need the program, there are QR codes floating around. You can get the program on your phone. We're trying to cut down on the use of paper around here. So this panel on the law of secrecy will lay the political and legal foundations for government transparency and secrecy. It'll also address the core tension between legitimate government secrecy and democratic accountability that is the main theme of our day today. And so I'd like to welcome our panelists to the stage, and I'll introduce the moderator, Carter Burwell. Carter is currently a litigation counsel at Debevoise and Plimpton, LLP in Washington, D.C. He's also had more than a decade in senior roles across the federal government. I won't list them all, but they include counselor to the Secretary of the Treasury for Terrorism and Finance Intelligence, and he's one of the top lawyers on the U.S. Senate Judiciary Committee. In February 2022, Mitch McConnell appointed Carter to serve on the Public Interest Declassification Board, one of the co-sponsors of today's event. Carter also serves as a law professor at the University of Texas School of Law and the Antonin Scalia Law School at George Mason University. As it turns out, he and I are distant cousins with roots in the tiny, tiny town of Millwood, Virginia. And as has been mentioned, he was part of making this event happen through conversations with Matt Connolly a year ago at another PIDB meeting, and we're really thrilled that this has come to pass. And so with that, I'll pass it over to Carter to introduce the rest of our panel. Thank you.
Thank you. Thank you, Paige, and it's really a pleasure to be back here at Columbia. I was a 1996 graduate of the university. Delighted to see that the university is still in the headlines too, and very grateful that we were able to gather today here, and grateful for Paige for having us, for SEPA, for the Saltzman Center, to learn more about Bob Jervis and his legacy. So grateful to Matt Connolly. This event really came out of our last event the PIDB had at the University of Texas last year, and so grateful to carry on that conversation again here. Last year we had Avril Haines came and spoke and made some really great statements about the role of classified information, the importance of it, but the importance of declassifying that information. Senator Cornyn came and spoke, also talked about these issues, but I am really grateful today to have a panel of outside experts, kind of outsiders, scholars, practitioners. I think so much of my experience in the national security community was conversations. Matt's book does a wonderful job of painting the picture of SCIFs and the secret room where national security professionals get together and talk about national security information. But it's so critical that we have these conversations in public with the American people, that we share these, that it's not just the experts on the inside, but scholars who come and talk about these issues, and practitioners who litigate these issues in court, especially as our battle for national security moves to kind of great power competition and the battle for information. And I'm looking forward to hearing conversations about that today. And I will briefly introduce our panelists. I'll start at the end. Professor Heidi Kitrosser is the William Gurley Memorial Professor of Law at Northwestern. She's an expert in constitutional law, in government secrecy and separation of powers and freedom of speech. She wrote a wonderful book on this subject called Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution. And I also saw that Professor Kitrosser and I have in common that we clerked for a district court judge and a circuit court judge, and that she spent some time, as we were talking about, at a law firm in Washington at the beginning of her career. Professor David Pozen, in the middle there, is a professor here at Columbia and teaches and writes on topics of constitutional law, information, nonprofit law, and a variety of other topics. Most pertinent to our conversation here today is his seminal work that he published really at the beginning of his career, I think, as a professor in 2013 in the Harvard Law Review, called The Leaky Leviathan, about the law of secrecy, but also the practice of secrecy, and how the practice of leaks form the undercurrent, almost a common law of secrecy. And I'm really looking forward to hearing more about that today. Professor Pozen does not just have experience in academia. He clerked on the Supreme Court and for a lowly circuit court judge named Merrick Garland in D.C., and also served as a legal advisor at the State Department for a couple years, so has experience in government as well. Lastly, to my right is Ben Wizner.
I forget.
He is the director of the ACLU's Speech, Privacy, and Technology Project, which works to protect and expand the First Amendment freedoms of expression, association, and inquiry. I learned last night that Ben started his career at the ACLU in August of 2001, on the eve of the September 11th attacks, and has spent the last 20 plus years of his career litigating issues involving national security. Issues like Guantanamo Bay. He's been representing Edward Snowden on issues of transparency and surveillance reform, and very grateful that he's here and is going to give us a view on how this works in courts and how the law, judicial common law is affecting the law of secrecy. Ben's a graduate of Harvard, NYU Law School, also clerked on the Ninth Circuit for Judge Reinhardt. So the lay of this panel, and we very much want to hear from you. Each panelist is going to speak for 5 or 10 minutes on their subject of choice, their expertise, and delighted to hear more about that. Professor Kitrosser is going to start us off with some of her work on the constitutional, legal, really foundational principles of secrecy in a Republican form of government and under our Constitution. Then I think we're going to turn to Ben and have Ben talk a little bit about his experience with those issues in courts, representing individuals and trying to change the law. And then lastly, Professor Pozen is going to talk about his work, which still is front and center in this world of secrecy, and grateful. So I'm going to turn it over to Professor Kitrosser.
Great.
And look forward to a lively discussion.
Well, thank you so much. I'm really thrilled to be here, and big thanks to everyone involved in organizing it. And this is, as a couple of others have mentioned, this is really quite a day to be at Columbia University. And it was interesting because I was brushing up a little bit on some facts about Robert Jervis's life in anticipation of this conference. And I saw reference to his proud participation, or his sort of proud recollection of having participated in the Berkeley free speech movement. And apparently he said he was very proud that he was almost arrested. So I so wish that we could ask him now, what he makes of today's events. So I, as Carter suggested, I am going to be talking about the constitutional framework underlying questions of government secrecy and transparency. Obviously, I can't lay it all out in 5 to 10 minutes, but I do want to start by saying that when I say framework, it might be a little bit deceiving, because not surprisingly, anyone who's even glanced at the Constitution could figure out pretty quickly, there's certainly no easy spoon-feedable answers, right, as to what the Constitution has to say about all of these things. But there are materials, there's text, there's history, there's logic, from which we make judgments and from which arguments come. And there are certainly a lot of arguments. And I thought the best way to kind of give a sense of key constitutional principles and arguments in this realm, is to lay out at least one, and then depending on how much time that takes me, possibly two, of the key presidentialist arguments in favor of sort of a strong presidential and more broadly really executive power to keep secrets. And by presidentialist, that's sort of shorthand for the idea that the executive branch, the president, as well as his subordinates within the executive branch, have not just a significant power to keep secrets, but really a preclusive power, one that would override the judgments of courts or of Congress, and that might even really preclude First Amendment analysis in cases where the First Amendment comes into play. So let me start by kind of explaining one of the key presidentialist arguments in this regard, and then I'll explain, in the spirit of debate, I suppose I'll debate what I just said, and suggest what I think is actually quite wrong, in my view, with those arguments. So the so-called presidentialist argument from a national security perspective, to the extent that when the president or a subordinate, often through a classification decision or possibly through some other sort of exercise of judgment, decides that it would be too dangerous for national security to be revealed, that really can't be second-guessed, or to the extent that any other player gets to have any role, it's one that has to be extraordinarily deferential. And that can manifest in a number of ways. We'll probably hear more details about kind of concretely how that manifests from the other panelists and certainly in discussion. But among the ways it can show up is in the context of refusals to grant FOIA requests, for example, to disclose documents. Oftentimes the executive branch might say, well, we can't because this falls under FOIA Exemption 1, meaning essentially it's national security information. And courts have tended to be extraordinarily deferential, very much afraid to sort of second guess the executive judgment there. Similar issues arise in arguments about the state secrets privilege, where the executive branch says X or Y piece of information cannot come into this litigation because it would be too dangerous to disclose. In some cases, too dangerous to disclose even in camera, just to the judge, and even where that would preclude the case proceeding at all and would have to lead to the case's dismissal. It also manifests in, for the most part, courts' refusal, the judiciary's refusal to consider First Amendment limits, or that there might be First Amendment limits on Espionage Act prosecutions brought under individuals for leaking classified information to the media. So those are examples of how it manifests itself, this principle. So what are sort of the key rationales given for these principles? Well, for these ideas. One is sort of a simple functional argument that it is the president alone, and more broadly the executive branch and his subordinates, who are able to make necessary judgments about what must be kept secret in the realm of national security. It's often said in this realm that only the executive has the kind of 360-degree view to sort of know all the elements. It's only the executive who knows how different pieces of information fit together. Professor Pozen, I think as a law student, wrote about the mosaic theory. As a law student, wrote about the so-called mosaic theory, the argument that the executive branch has to be deferred to in their secrecy decisions because only they can understand how the different pieces that might look innocuous and isolation sort of fit together. So partly these functional arguments about executive branch supremacy in this realm. Sometimes those are coupled with historical arguments, that essentially amount to an argument to the effect that the founders expected that the president would act with secrecy. Often the so-called Hamiltonian virtues are referred to, statements which were reflected in the words of others, not just Alexander Hamilton, but most famously can be traced to a Federalist paper written by Alexander Hamilton in which he referred to the president's capacity for secrecy, dispatch, vigor, energy. And in addition to that, advocates of sort of strong or even preclusive presidential powers here point sometimes to constitutional text. They're very big fans of the so-called vesting clause, which is the first line in Article 2 of the Constitution. It says the executive power is vested in a president of the United States, and favoring very strong preclusive presidential powers. Advocates of this approach often like to say that the vesting clause may look introductory, but actually what it does is bequeath to the president a whole bundle of rights, many of which would have attached to the crown previously, minus those that are taken away specifically given to Congress or others elsewhere in the Constitution, and that this clause includes, among other things, very strong secret-keeping power. Now, I'll just note that I actually think these arguments are quite problematic. Just quick sort of bullet point sketch of what's problematic about them. So first, on the functional realm, absolutely, there's sort of a degree of sort of knowledge and expertise, partly through specialized access to information that the executive branch brings to bear. But the sort of leap from that to the idea that the executive has a preclusive power, right, that they're sort of the only responsible voice in the room, I think is obviously problematic functionally. It first of all, remove sort of other values from the debate, including the possible negative impact on national security of secrecy, as well as other values, democracy, accountability, and also makes the mistake of assuming that only the executive has the ability to sort of weigh in on these issues. Historically, references to things like the Hamiltonian virtues, I tend to think is a misreading of history. I think that it sort of conflates an intention that the president, and a reflection in the constitutional text, that the president had the capacity to act energetically, including to keep secrets, necessarily is the same thing as an unbridled right to do so, even in the face of counter judgments by others, including as represented by other branches. And textually, suffice it to say, and if anyone really wants to get into the weeds of constitutional text, we can talk about it more in Q&A, but suffice it to say that I tend to think strong presidential power advocates massively overread the import of the vesting clause and also tend to overlook that there are a lot of other clauses in the Constitution. Let me just say, I think I have time to just spend 1 minute saying I wanted to mention one other constitutional idea of presidential power that's not as often connected to secrecy, but actually I think does have a big impact on presidential secrecy, and that is the so-called unitary executive theory argument. Many of you may have heard that term, but it's often not really defined with much precision. Sometimes it's conflated with broad presidential powers generally. Essentially, a unitary executive theory argument is an argument to the effect that whatever power the executive branch has, the president ultimately has all of it. And so whatever power the executive branch has to be under complete presidential control at minimum. This is put forth as a basis for allowing the president sort of unfettered at-will dismissal power over anybody who exercises discretionary executive power. Most radically, it's been sort of mobilized of late behind the idea that perhaps the civil service, wide swaths of the civil service, should be effectively abolished in favor of at-will employees who are political appointees. I won't go through all of the rationales for the argument, but I will say that one of the key rationales is, interestingly, an argument from accountability. The argument is that only if the president has this power over his underlings can people ultimately hold him responsible, know that the buck stops there, and then voting will be more meaningful, the president will be more accountable. Real quickly, I think that, too, is a very problematic argument. I think it's a very shallow vision of accountability, and it overlooks the ways in which a unitary executive power actually can undermine the ability of the people to learn about what is going on, including presidential misdeeds. Case in point, inspectors general, right? There are some who are arguing, in light of particularly some of the controversial firings of inspectors general during the Trump administration, that they should be given some sort of for-cause employment protection. That butts right up against the unitary executive theory. And that's an example of how it can sort of conflict with the ability of people to investigate and find out what's going on in their government and hold them accountable. Okay, I'll stop there. I look forward to the conversation.
Thanks so much, Heidi. I think you've done an incredible job of laying the groundwork, which is that the law of secrecy is executive primacy. At least that's the way we've interpreted it for so long. And hopefully we can have an interesting conversation about the consequences of that for democracy, which preceded the president. We did get rid of a king a while ago, and whether or not that's in practice. But I'm sure, Ben, you've got some interesting thoughts about your challenges to executive primacy and the president and the executive branch's enforcement of the law of secrecy. And so welcome your thoughts.
Thank you. I appreciate that. And I'm honored to be on this panel with two friends who have done some of the most important scholarship on the uses and misuses of secrecy, and a new friend who is also, like me, a practitioner, albeit usually on the other side of these things. In the spirit of this conference, Matt Connolly mischievously placed me at the dinner last night between two longtime luminaries of the CIA. We'll see if they want to sit with me at lunch after my remarks today. They might lose their security clearances. As Carter said, I am a practitioner. He said that I have spent the last 2 decades litigating our country's response to the 9/11 attacks. I think it would be more accurate to say that I have spent those decades attempting to litigate our country's response to the 9/11 attacks because of the uses and misuses of secrecy. And I think that this is not as known as it should be to the general public and even to experts outside the law, how much of what our country did has been deemed totally non-justiciable by courts. Was the CIA's torture and secret prison program lawful under US and international law? Are there Fourth Amendment limits on intelligence surveillance within the United States on American citizens? Are there any limits imposed by US law on targeted killings that are aimed at American citizens, far from traditional battlefields? These are questions that were placed before courts and that courts uniformly refused to grapple with or to answer because of executive branch invocations of secrecy doctrines. I think sometimes when we try to tackle the question of secrecy, we are guilty of a category error, and that we really need to be thinking about this not only as a secrecy crisis, but as a justiciability crisis and an accountability crisis, and that all too often in national security litigation, disputes over secrecy are really operating as a proxy for disputes over accountability. So I will start with an anecdote, if you'll allow. In September of 2011, Harvard Law School and the Brookings Institution held a 2-day conference to mark the 10-year anniversary of the 9/11 attacks. And the lunchtime keynote speaker was John Brennan, who at that time was President Obama's chief counterterrorism officer, would go on to become the director of Central Intelligence. And I decided to line up in the queue to ask him a question. And when it was my turn, my question was, does the CIA have a drone program? There was a little bit more laughter than we just heard here in the room. And Brennan's response, and I want to make sure I get it exactly, was, well, as you know, covert actions are designed to be covert, and therefore, I interrupted, you only read about them in the newspaper. And then his response was, if the agency did have such a program, I'm sure it would be done with the utmost care and precision in accordance with the law and our values, if such a program existed. Now, if you're not familiar with national security law and litigation, you might be asking, what the hell is going on here, right? In 2011, the CIA's drone program was extraordinarily well known by that time, and it was in the newspaper almost every day, and those stories were sourced to senior government officials. You'll hear more about that kind of sourcing maybe from David. So why can't Brennan answer that question? Yes. And he can't answer because to answer at all would, in his view, weaken what is a central pillar of the intelligence community's impunity regime, and that is that there's a critical distinction between what's universally known and what's officially confirmed. It's this distinction that has allowed the intelligence community to use its authority over secrets to be deployed as an almost insurmountable liability shield. Let me show you how it works. About 2 weeks after my exchange with John Brennan, Anwar al-Awlaki, a US citizen who was born in Las Cruces, New Mexico, was killed in Yemen by a Hellfire missile fired from a US Predator drone. This was not a surprise, and it wasn't a surprise because the entire world had known for months that the United States had marked al-Awlaki for death. And that's because in early 2010, senior officials of the Obama administration, in a coordinated leak strategy, had gone to major newspapers to provide the information that al-Awlaki had been added to kill lists that are maintained by the CIA and by the Pentagon's Joint Special Operations Command, or JSOC. They wanted the public to know about this controversial decision based on undisclosed criteria. Maybe it was a trial balloon, but it was certainly a deliberate strategy of the administration. And so following those disclosures, the ACLU and other public interest groups went into court, and we thought that the court should answer some basic questions about what the rules were under US and international law for when or whether it might be lawful for the government to target its own citizens and others for death in this way. And these are questions that courts in other democracies have grappled with. Notably, the Israeli Supreme Court has grappled with this question. And in response to our lawsuit, the government, having deliberately placed this issue into public debate through its leaks, now decided that having that debate in a courtroom would disclose state secrets and harm national security. And I will read from the sworn declaration from Secretary of Defense Robert Gates. He said, "Disclosure of whether or not lethal force has been authorized to combat a terrorist organization overseas, and if so, the specific targets of that action would provide the nation's enemies with critical information needed to evade hostile action." I mean, this is head-spinning, because if it's true, it was obviously the administration's leaks and not our lawsuits that had created the danger that Secretary Gates was asserting. And this is a pattern that you see throughout national security law and litigation, that the government will place information into the public sphere, and then it will claim secrecy doctrines when it's faced with any kind of legal challenge. In February of 2008, I was in a federal court in San Jose, California, representing 5 victims of the CIA's torture program. The CIA moved to dismiss that case based on an affidavit by then CIA Director Michael Hayden, asserting that any confirmation or denial of information about alleged interrogation techniques would harm national security, disclose state secrets. On the very same day, Hayden was testifying before Congress and disclosing for the first time the CIA's use of these interrogation techniques, including waterboarding. And so by deploying these selective leaks to the public and to the press, and secrecy claims at the same time in the courts, the government can simultaneously manipulate the public debate by introducing just what it chooses to release, and then avoid meaningful accountability and judicial oversight. And of course, the flip side of this impunity for the national security officials is strict liability for dissenters and leakers. We can discuss this more, but the Espionage Act of 1917, which is the principal vehicle for prosecuting unauthorized leaks to the press, doesn't distinguish between leaking to the press and selling or giving secrets to a foreign enemy for personal gain. And in fact, in a recent leak prosecution, the Justice Department took the remarkable position that unauthorized leaks to the press are more pernicious than typical espionage cases where a spy sells classified information for money, because when you leak it to the press, every foreign adversary, and not just one, stands to benefit. In that formulation, the public may also be an adversary. So I could give many more examples. I'd much rather get to our discussion, but I will just say that every lawsuit filed by a victim of the CIA's torture program, every single one, was dismissed without any adjudication of the law or the facts, based on declarations by the CIA director himself that litigation of those claims would reveal state secrets and harm national security, meaning that the law as it stands is that the government can engage in torture, declare it a state secret, and by virtue of that designation alone, avoid any scrutiny or legal accountability for conduct that has always been deemed illegal in all circumstances. And this is, there's a lot of words for what's going on in these cases, and I would say secrecy isn't the best way of describing it. I think this is an accountability crisis of the court's own making. I think that there is a common law of secrecy here that has regarded the government's even legitimate secrecy claims as absolute, and that there's an important role for judges to apply some kind of sense of proportionality, so that even when the government is asserting a legitimate and not an illegitimate secrecy claim, the court can balance that interest against other important interests, like providing a forum for a victim of human rights abuses, giving the country an adjudication of an important question, so that maybe when the next president comes in, we have a court that has said actually torturing prisoners is illegal. I will leave it at that for now, and I look forward to the discussion. Thanks.
Thanks, Ben. So we've heard about executive presidential primacy, and we've heard about resulting impunity, judicial acquiescence to this regime. Professor Pozen, how did your study of the leaky Leviathan reveal how this works in practice?
Thanks, Carter. I want to just say that I did not know Bob Jervis well personally, but deeply admired him from across the quad. So I'm really honored to be here. And Matt Connolly is one of my academic heroes as well, and I deeply admire my co-panelists. So that said, the tumultuous times here at Columbia have already been alluded to. I've been swept up in it myself and feel quite rattled by recent events. So I apologize if that affects my remarks or performance here. This study that Carter is talking about was my first paper as a law professor, Leaky Leviathan. And if we've heard some about the law of government secrecy, that paper is really addressed to the practice and how in some surprising ways it departs from the law on the books. The motivating observation of that article is that while there's often talk of the war on leakers that's going on and the crackdown, and this was a big theme in the Obama years, what's really striking is the radical under-enforcement of the criminal prohibitions on leaking of national security information to the press. Because while it's hard to get precise estimates, if you look at the number of disclosures of classified documents or items to the media that get published that seem to fall within one of the many provisions of the US Code that allow for the prosecution of that kind of disclosure, and you compare that denominator of potentially prosecutable leaks to the number of cases actually brought, you learn that well under 1% of potentially prosecutable leak cases are actually pursued. And therefore, the puzzle, I think, is not why we saw an uptick under Obama so much as why the rate of leak law enforcement is so low, so remarkably low. The paper then considers some of the standard explanations that are given, like it's difficult to catch the leakers. President George W. Bush said that once, and tries to explain how that's not really plausible. Some of the difficulties in catching leakers are endogenous to the design of the enforcement system, and when you don't use your strongest tools, like subpoenas to journalists, to go after leakers, it's predictable you'll find it harder to catch them. But when the executive has actually tried to catch leakers, the evidence suggests it's pretty good at it for the most part. And you also hear that the very act of bringing the prosecution could elicit uncomfortable disclosures at trial. That account, I think, underestimates how effective the Classified Information Procedures Act, CIPA, can be in managing that kind of situation in the courthouse. And I'll spare you the full story, but I try to debunk the narrative that it's just too hard to catch these guys or bring these cases. Rather, I think there's been an intentional decision or set of decisions to keep leak law enforcement low. And most of the paper is this elaborate account of why that is adequately functional for the executive branch. Yes, sometimes leaks will happen that are damaging or uncomfortable. That is the price of allowing such leakiness. But for the most part, it allows the executive branch to serve a lot of objectives in a reasonably efficient manner. It can float trial balloons and test out the public or congressional response to various initiatives. It can plant stories that make it look good or occupy this middle space between plants and leaks that I call pleaks, where things are semi-authorized or it's looked the other way, but it's actually quite useful to get it out there in some fashion to the media. It placates the media and congressional overseers who might demand more formal disclosure if you didn't have so many leaks. So I end up saying that, there's an elaborate system of informal norms and sanctions that do much of the regulatory work of keeping leakiness within bounds. So while very few prosecutions are brought, that doesn't mean that no one's getting punished for being seen to have leaked in destructive ways. They may not be promoted, they may be not given certain clearances, they may be kept out of meetings or working groups. There are a lot of informal levers by which people can be disciplined if they're suspected to have gone too far, short of bringing in the criminal sanctions. In addition, there are a lot of norms that I think have developed, at least in the upper tier of the executive branch, to constrain what people say, where people know that they're not, for example, supposed to disclose names of operatives. They're not supposed to sell information. And this has, again, kept the situation tolerably within national security bounds for the executive branch. It doesn't mean that it's, however, the best way to manage national security information. It just means that the system has evolved to allow for adequate pathways of information disclosure against the backdrop of extreme overclassification and, as Ben discussed, largely judicial and congressional abdication of a significant role here. So the way I see it, there are two basic equilibria for how we might manage national security secrecy. You can either have what we do have, which is massive formal secrecy, a huge classification system that's very difficult to penetrate through the Freedom of Information Act or otherwise, coupled with a very loose informal disclosure regime where you have lots of leaks and thereby serve the executive branch's own interest and placate constituencies in civil society and Congress. The other equilibrium that would be a much more streamlined official secrecy system and fewer leaks. Under that version of a secrecy regime, we would have a more robust congressional and judicial role in managing the secrecy system. In other work, I've discussed how that was actually on the table in prior periods in US history. In particular, in the 1960s, Congress actively considered several bills that would have legislated a national security classification system. And those bills, however, never got to the floor, never really moved. But that was in a window of time, let's remember, when Congress was pushing back on the executive on a lot of fronts in the wake of Watergate and Vietnam by the time we got to the early mid-70s, and passing framework statutes like the War Powers Resolution and FOIA, and then the FOIA amendments in 1974. So this was a time of political possibility when it came to Congress constraining the executive branch on national security matters. What Congress did instead, after toying with the idea of taking over the classification regime itself, was to beef up FOIA. So the Freedom of Information Act is enacted in the mid to late 1960s. In 1974, it is amended by Congress specifically to authorize de novo judicial review of withholdings of records under the national security exemption, Exemption 1. And on paper, this is an extraordinary thing I just want to call attention to, not replicated in other democracies, where courts are told not only that they can review secrecy determinations by the executive branch made in the name of national security, but they are to apply zero deference, none, de novo review to those determinations. But what in fact transpires is courts want nothing to do with this. They usually grant summary judgment without even engaging in discovery or doing any in-camera review in Exemption 1 cases. So Congress, I think, mistook the judicial appetite for playing this supervisory role. And by not trying to set rules for classification that it would oversee itself, basically outsourced the constraints on the secrecy regime to civil society and this kind of pointillistic approach where people who happen to hear about some program and are worried about it submit a FOIA request and case by case try to convince an agency and then a judge to disclose the documents. That approach is slow, it's reactive, it proceeds piecemeal, and again, it relies on judges to do more than it seems they're eager to do. And then in the backdrop of Congress, kind of checking out by the mid-1970s and courts declining to engage in serious review of Exemption 1 and Exemption 3 claims, you get the rise of national security secrecy within the executive branch, and then this massive leakiness and under-enforcement to make the system sustainable. So that's my basic reconstruction of how we got where we are now. I'll just say at the end here, because I know people want to talk about reform in this Congress, what we might do. I think this point about judicial unwillingness to review secrecy claims when national security is at stake is a very difficult one for reformers, because it is a hard institutional design question to think about how to set tougher rules on classification or declassification in the absence of vigorous judicial enforcement of those rules. You could try to send an even stronger signal to the judiciary that, no, really, we mean it, de novo review, or you must engage in in-camera review of some documents, or you must demand redacted summaries, or you must allow cleared counsel from the other side to challenge the claims of the executive branch. You could imagine even sharper directives to the courts to engage. But there's something about the sociology of the judiciary or the judge's utility function that makes that hard. That might suggest that Congress itself is going to need to be more intimately engaged in supervising classification, which is a role it hasn't historically wanted to play itself. The leaky Leviathan piece, really the key contribution of it, if it makes one, is descriptive, explaining how really the better way to understand all the leaking, the war on leaks that we often hear about, is that it's a remarkably surgical special operation. Compared to the backdrop of leaking that actually occurs, it's a remarkably restrained exercise, which calls out for explanation. But hopefully that kind of descriptive exercise might inform reforms that we can talk about today.
Thanks a lot. Thanks to everybody. I'm going to try and come back to Heidi with a question and kind of lay it in the context of what I think is, this week the United States Congress is trying to reauthorize Section 702, one of these critical surveillance tools that the United States uses to with Ben here next to me, I need to be cautious, but to intend to spy on adversaries overseas. That bill passed the other day in the House, I think by one vote, and is being debated right now, I think, on the floor of the Senate in the next 24 hours. What are the consequences to our democracy of having a very executive-focused system and one that a judiciary might be abdicating? And how does that go back to this kind of core tenet of Republican government or our Constitution?
Yeah, that's so I guess, sort of two things embedded in there. One, this really key core overriding question about a system that's so executive focused, and then, to the kind of the specific example of surveillance. So on the first question of sort of executive dominance here, I think the consequences are multifold, but almost entirely bad from my perspective. I think perhaps the most stark consequence, as I think in our own way each of us sort of got at to some degree, was that executive dominance threatens accountability, right? And that's not necessary, and it doesn't really depend on who the particular president is, although certainly, some individuals we would, maybe feel sort of less worried about than others having this level of sort of preclusive power that you heard Ben and I describe in particular. But it takes someone who, has an interest, is not an uninterested party, and essentially leaves it entirely to them. And so it has the effect of sort of placing all weight in decision-making really on one value, right, which is national security, not democracy, not public interest that might be illuminated through information disclosures, not accountability. But perhaps even worse, or at least as bad, it looks entirely to one branch and often one person, right, and who is often a very interested party, perhaps demonstrated most starkly by the state secrets privilege, including a couple of the examples that Ben gave of the use of that privilege. So it sort of defers entirely to them. I think perhaps the starkest consequence is for accountability, right? Again, in the way I think Ben's examples illuminated. And I think so the topic of surveillance that you started with helps to illustrate this, right? To the extent that a sort of enormous secrecy powers are essentially left without much, if any, checking to the executive, backed up by judicial acquiescence, for the most part congressional acquiescence. When that's also coupled with sort of enormous executive branch tools to surveil, based in part or grounded in part on sort of executive say-so, right, and faith that, well, we're not abusing this, we're not targeting it against, for example, journalists, et cetera. That can also add to the chilling effect of tools that are used more directly against information disclosures, like the tools like the Espionage Act. So all in all, I think our current system and the current sort of extreme deference, if not complete abdication, of the weighing of interests to the executive branch, it threatens a lot of things, and it threatens a lot of things in a lot of different ways. I think it could be counterproductive to national security itself, among other things, but perhaps most importantly, it deeply harms accountability and the ability ultimately of the public to have any idea what's going on, and therefore meaningfully to judge their elected officials and the state of the country, and our progress on various matters.
Dave or Ben, do you guys care? Ben, you probably have thoughts on that.
I guess I would say, the way that the executive branch likes to discuss this conflict in litigation, when we go into court on behalf of an alleged torture victim, and the director of central intelligence comes into court and says, this case must be dismissed. The framework they say is, there are times when the interests of an individual litigant are in conflict with the public interest in national security. And regrettably, in some of those instances, the interests of the individual litigant must be subordinated to the broader public interest in national security. And I think that's a very narrow way of looking at it. I mean, I would say at a minimum, there are public interests on both sides of that equation. That there's a public interest in having some of the most important questions about the relationship between national security and individual rights adjudicated by a court. There's a public interest in having a court system that is open to those claims, and a public interest in having remedies available for victims of those claims. And so I think it's not so simple as just the individual litigant against the country on the other side. I would also say that the particular way that deference operates here is troubling. I believe there is security expertise, but what happens here, where you actually have the party alleged of wrongdoing demanding deference to their own expertise, is we have a structural conflict of interest. I would argue courts would do better to give less weight when the person coming into court demanding deference is not the same person who is here accused of overseeing this kind of really massive wrongdoing. And I agree with what Dave said. Courts are unbelievably reluctant to play the role that I am asking them to play. If you've ever been involved in this, I mean, sometimes there will be a security officer from the Department of Justice who will deliver the secret affidavit from the Director of Central Intelligence to the court in a briefcase handcuffed to his wrist and go back into chambers to show this, then it will say, you know, if this case goes forward, the oceans will boil off. You'll be responsible for all of the blood that's going to flow. And there's very few judges who are going to say, you know what, I think you're exaggerating. But I think they have to. I think they need to look at these kinds of declarations in the context of the kinds of claims that have been made in the past. And there has been, you know, routine, you know, exaggerations. You have to look at the motivations here. I think courts, and courts should look to courts in other democracies, right? And it's not that the security threats against our country aren't real. I would say they aren't more severe than they are. I gave the example of the Israeli Supreme Court a minute ago, which has actually answered all the questions that I said that our courts have refused to answer. When can extreme interrogations be used and when not? What are the limits and rules for when the government can use targeted killing? They don't say, because the government asserts national security, we're not going to answer this question. They say to the government, you're the experts in security and we're the experts in proportionality. You can tell us what the security rationales are. We're going to listen to those very carefully, but we're going to balance that against human rights norms and other interests. And then maybe if you want the security fence to be here, we're going to say it should be here. That's not something that our courts do. And I think our courts need to be in more dialogue with courts in other democracies that have faced threats in order to sort of get the muscle to play that role.
I'll just add a point or two to that. On the court's unwillingness to second-guess executive branch claims of national security secrecy, there's a whole cottage industry of comparative administrative law studies that look at administrative law regimes where courts are supposed to defer to the agency's determination of some matter, but nonetheless reverse the agency 27% of the time or something. And you compare those regimes to the FOIA Exemption 1 regime, where courts, again, are supposed to give no deference, de novo review to the agency, and reverse the executive branch basically 0% of the time, just above.
A good way to get yelled at by a judge is to tell a judge they're supposed to give de novo review to a
Formal standards of review clearly aren't driving judicial behavior here so much as background sets of norms or incentives. So that might lead us to look at Congress itself, right, as a source of checking and indeed disclosure. And here I'll just note that Congress has also shown a remarkably low appetite for getting, since the 1960s and early 70s, getting proactively engaged here. It hasn't taken up again this effort to legislate a classification regime. I agree with Heidi that I think that Congress has the authority under the Constitution to do that if it wished, but it hasn't even tried. And then it does have other tools. The speech and debate clause, for example, insulates from potential prosecution whatever members of Congress might say in the course of their legislative duties on the floor. And as you may recall, Mike Gravel famously read part of the Pentagon Papers into the congressional record as that was being broken in the press and in what he thought was a kind of patriotic act of disclosing executive branch abuse. It's striking that more members of Congress don't even try to invoke their powers under the speech and debate clause to push back against what they see as excessive executive branch secrecy. That's a costly strategy and a hard one, to generalize that individual members go rogue and read something into the record, but it's completely fallen out of our practice in a way that I find remarkable.
The closest is Senator Wyden, who gets up there and barks like Lassie every once in a while.
I think that's kind of the exception that proves the rule, because Wyden has often said, I'm very alarmed by what's happening, and I wish people would talk about it and tell us, one wants to say to Senator Wyden, if you could do it, you'll get kicked off the Intelligence Committee, and it's problematic for an individual member of Congress to do that. But it is constitutionally an available move to you. Maybe with more restraint and safeguards. The Intelligence Committee, since their inception in both the House and the Senate, we were talking about before we came on the panel here, have rules that allow them to declassify national security secrets. The rules require a majority of the committee to agree that something the executive branch doesn't want to disclose ought to be disclosed. The executive branch can push back on that, and then I believe it goes to the full body, and there has to be a majority vote there. And perhaps the executive branch would win a lot of those fights, or perhaps the members of those intelligence committee, by and large agree with the executive branch's classification decisions. But as far as I could tell, and I once had a student write a note under my supervision who tried to dig into this, those provisions have hardly ever, if ever, been invoked by the intelligence committees. So there is a tool that does have safeguards. Members of both political parties have to be involved, the full committee, potentially the full chamber. And the intelligence committees haven't wanted to use that tool. So I think that this all suggests what one needs a cultural shift as much as a change in the formal legal authorities to begin to get at executive branch secrecy if indeed it's seen to be out of control.
I'll give a reference to my colleagues from the Public Interest Declassification Board who reminded me that the Atomic Energy Act, which was passed in the early 50s, I think, set up a system of secrecy, legislative system of secrecy for nuclear material. And then I was reading up on Senator Moynihan's efforts and his commission, I think, to try and propose a new framework that went nowhere. Congress did pass a very small provision last year, and the included it in the NDAA to kind of promote greater declassification, but it's a challenge. I wonder if you had thoughts when Deanna Haynes came to Austin last year. She talked about the crisis for public trust in the national security world as a result of our battle over information and misinformation, and the challenges that a hoard of government information is kept from the public, and the consequences that has for our faith in our government, our trust in our government. And is there a way out here through, now you see the executive branch promoting declassifying information in support of the war of Ukraine? There's been a lot written on that. Not a lot of domestic issues, though, for declassification. Do you see that crisis of trust in your work and how do you see it manifest itself?
Yeah, well, I'll just say one, I think it absolutely does, among the many other problems of massive overclassification, is that it does enhance, I think, sort of conspiracy theorizing, and this sense sort of gives more fodder to it, right? The idea that there's so much being kept secret from us, that in addition to legitimate concerns, right, about sort of specific things that the government is not disclosing, also lends itself to conspiracy theorizing, right? Well, they don't want us to know that really, 9/11 was an inside job or whatever, or what have you. And as to ways to get out of the mess, I mean, as I think everyone has alluded to, it's an really gargantuan problem, no easy solutions, right? There is, as Dave talked about, the 1974 FOIA amendments, if you just look at them on paper, they're really quite remarkable. Courts haven't wanted to use them. Congress often is reluctant. I think that's for a variety of reasons. I think partly there's just not a whole lot of political incentive in forcing something out into the open, particularly if it's some relatively obscure issue that people aren't focused on. In many ways, I think ignorance is sort of bliss if you're in Congress, and then you can wait for something to come out and either complain about it or complain that you weren't told about it, or claim you were on the right side all the time. I do think, I tend to think that in addition to various sort of legal changes, which I think would help at least move things along. I mean, changes to the Espionage Act, for example, amendments that have been proposed, as well as ideally sort of a judicial recognition of the First Amendment interests at stake when someone is prosecuted under the Espionage Act. for disclosing classified information, perhaps statutes that would provide for sort of greater congressional participation in sort of the classification regime beyond, maybe sort of broader-based things along the lines of what was done with the Atomic Energy Act, I think are certainly worthwhile steps to pursue. At the end of the day, though, as I think Dave was just saying, I think a cultural shift ultimately has to take place, and that's a long game. I think one small piece of that might be, as one of the speakers, I can't remember who, mentioned earlier, learning more from our history, right? Maybe it was Ben who mentioned that, so often we look back now and can sort of scoff at what are now, in retrospect, obvious exaggerations of how the heavens will fall if this or that piece of information gets disclosed. I think stories like that perhaps are helpful in moving forward a cultural shift. I guess the last thing I'll say in this regard is my favorite example of sort of learning from history like that was an op-ed that Erwin Griswold wrote in 1987 in the Washington Post. He had been Nixon's Solicitor General and had actually argued on behalf of the Nixon administration in the US Supreme Court for literally stopping the presses to ensure that the Pentagon Papers couldn't be published, and offered sort of the parade of horribles that would surely happen if the papers continued to be published. He published an op-ed in the Washington Post 16 years later, essentially saying that he hasn't seen any damage to have resulted from that, and he had some remarkable language to the effect of people who work in national security, anyone who regularly accesses classified information could tell you most things that are classified don't need to be classified. They're often there. They're often classified in order to prevent embarrassment, et cetera. So one small piece of the cultural shift has to be maybe paying more attention and learning from history, but it's a tough slog.
I'll just, Heidi makes great points. I'll just say on the trust question that Carter asked, is one reason to pursue reform here to enhance public trust. I have a contrarian take here, actually, on this panel of good Obama liberals or whatever we are, in that I actually don't think trust is a reason to pursue reform. I say that because of a few reasons. One is that the collapse in public trust in government institutions that the country's undergone since the 1970s is multi-causal. There are a lot of things driving that, I think. So the idea that if we just have a more streamlined classification system, we'll get enhanced trust is I think, naive. But more than that, there's actually a pretty robust finding in the comparative transparency literature that opening up government institutions does not increase public trust in them. If anything, the causal arrow may run in the other direction. Much of the US government outside of the national security state involves world historically transparent bureaucracies. The National Labor Relations Board or the EPA, these are incredibly open institutions compared to historic norms. That hasn't led to great public trust in them in an age of a fragmented media culture and hyperpolarization and inequality and all the other drivers of the decline in trust. And some people go further and say, really, if you make a government institution broadly accessible to the public, you invite unrealistic standards about how that institution will operate. When people see how the sausage is made, they tend to be appalled, not placated, and you create a dynamic whereby people always want more information, and something will always be withheld. And once you kind of create a new set of entitlements or expectations about what's going to be revealed, people never actually end up feeling satisfied. They just want more transparency. So I really don't think a great reason or plausible expectation for classification reform would be that Americans would then trust the national security bureaucracies more than they do now. I think that the best reasons sound in accountability and democracy and don't need to rely on the phenomenon of trust.
It also matters how information comes to the public, and I know there were a lot of conversations in the Intelligence Committee community in the wake of the Snowden leaks that we probably would have been better off putting some of this information before the public through our normal declassification channels, because there would have been less of a whiff of scandal around it. We would have been pretty good at defending our need for these kinds of authorities. But the way that it comes out in this dramatic way on the front page of newspapers, winning Pulitzer Prizes for investigative journalism, now we're in Congress and, courts are all of a sudden paying more attention. Congress gets a little bit of oversight appetite. So, one would hope that one of the shifts, and we'll hear more about this later from people who have been inside these rooms, is when you're deciding, does something need to stay classified, what would be the effect of this being leaked as opposed to just being declassified by us? And obviously there's some information that should be neither, and the names of undercover operative, troops movements, invisible ink I heard last night is in that category. But for the most part, we're seeing more and more leaks at scale, not just the Snowden leaks, but the Panama Papers and things like that, where big data leaks are going to find their way to the public. And I think it would behoove the government to get ahead of that in some ways by releasing more of that information on its own terms. Now, I don't think that will happen with the information that I care most about for the reasons that I said before, which is that keeping it formally secret is a way of keeping it non-justiciable.
Thanks. We want to provide an opportunity for people to ask questions. But before we do that, and I think people are going to circulate with microphones and make sure, I just wanted to make sure to give the panelists an opportunity for any kind of parting words or observations about, we've heard a lot about Congress trying to take the field or encouraging judges to act. Is there anything the executive branch can do?
Yeah, well, certainly there, among other things, I mean, there are a number of things that could be said there, but I'll just focus on kind of the phenomenon of internal checking. A number of people have talked about the importance not only of external checks on the executive, from Congress, from the judicial branch, but from the American people, but there is, and to some degree, there are already some systems in place. There's a lot of potential for a robust culture of internal checking. And just one of many examples of that, maybe one of the best examples of that would be the Inspector General system, right, which I alluded to earlier. That said, in order for such checks to be effective, arguably, protections need to be in place so that the individuals charged with checking have some degree of political independence, which brings us back to executive branch arguments for, sort of a preclusive presidential power to make all decisions within the executive branch, hence the opposition within the executive branch to the possibility of imposing some job protections on an inspector general. So yeah, I guess the short version of that is I think internal checking is deeply important, not just because of whatever might happen on the inside as a result, but also because sometimes that's the way information can trickle out and ultimately get to Congress, get to the other branches, get to the American people. But there are challenges, including things like unitary executive theory, that I think would preclude most legal protections that might help facilitate internal checks.
I'll be very brief so we can get to Q&A, but just to add to that, there's also the Public Interest Declassification Board that you referred to earlier, which from what I could tell from the outside is a very impressive body with an impressive track record of disclosure, although operating right now on a small scale and focusing on older documents rather than current classification decisions for the most part. Matt, as you may know, has kind of pioneered a bunch of technological tools that are meant to expedite the process of declassification within the executive branch. I think that could help. A more robust whistleblower regime might be coupled with Heidi's point about inspectors general playing a bigger role. So there are internal to the executive branch moves that I think could help at least at the margins. Although without a larger congressional role, I don't think there'll be fundamental change.
Let's open it up.
Okay. Thanks. I think there are microphones moving around. No?
Are there?
Yes, there are. So I think you had your hand up first, yes.
Hi.
Sorry, behind you,
microphone.
sir, there's a student with a microphone.
Hi, thank you so much for being here. This has been really interesting. My name's Lily. I've worked at the Office of Inspector General for GSA before being a student here. After, I'll be at the OIG for DOI. And we've had a lot of feedback on FOIA just taking forever to get information out to the public. The inspectors general are very small. The offices are very, very small. And I'm an internal auditor. and couldn't agree more. But each audit takes a year, and our audit team's like six people in a region, so it's absolutely impossible to really, speaking on behalf of myself, not on behalf of inspectors general, there's a lot that can be done to increase the effectiveness of having these streamlined ways of getting information to the public. Is there any, so my question is, do you see any reforms in like growing the inspectors general, making FOIA more streamlined to get access, because even that can take months or years? What do you think the future of this information, like freedom of information, looks like?
I could say a little on FOIA, the FOIA piece. One anecdote is just for that article that Carter spotlighted, Leaky Leviathan, published in 2013. I submitted a whole bunch of FOIA requests for how executive branch agencies have been handling leak allegations, looking for data on how many investigations had they brought or cases had they brought. And that was in 2012 that I submitted those FOIA requests. With the help of a research assistant, I got expedited status from the FBI because there's a statutory provision that says if you can show that what you're requesting could inform a pending legislative debate, and there were debates there were bills in Congress at the time that would have gotten at national security secrecy, you can get moved to the top of the queue in FOIA. And I was surprised, but I won expedited status from the FBI. It is now, 2024. I have still not received a document from the FBI.
A one-year audit sounds great.
Yeah, so good. So,
expedited.
So count your blessings.
That's an extreme case, but
It's not.
Maybe not. But the FOIA is inherently slow and reactive. I would say in the FOIA kind of reform community, some people are keen on non-judicial mechanisms of review. So ombudspersons and the like which are happening at a small scale now, where in a quicker and lower cost fashion, you can challenge invocations of any exemption, including Exemption 1, and get this kind of internal checking. So there might be ways you could speed up the FOIA process at least a bit and kind of de-judicialize it a bit in ways that might be helpful. But I am fundamentally skeptical about FOIA as the answer here, given its slow and reactive nature. That's not even, we haven't even mentioned the fact that to even submit a FOIA request, you need to have the prerequisite knowledge to know what you're looking for and describe it with reasonable specificity, which is a big problem when it comes to secret operations.
Dave, haven't you also written about affirmative, affirmative disclosure regime?
I'm more keen on affirmative disclosure strategies whereby certain categories of information systematically and proactively have to be put out into the public as mandated by Congress, which FOIA also has elements of, but largely don't apply to the national security state. So that, and that can be done, by the way, not in an all or nothing fashion, but releasing high-level summaries of what, say, Snowden was talking about rather than any details. I think moving away from requester-driven models to affirmative disclosure obligations is generally best practice in this area.
And there's a law professor named Margaret Quokka at, I think she's at Ohio State now, who's written a lot about this and has also made sort of affirmative disclosure proposals. Her work is really enlightening. The only other thing I would add, particularly in light of what you were saying about the limited resources in the IG's office, is, it seems so obvious to say, they need more money. But, it is amazing that so often this is where the rubber meets the road. I teach a seminar on government secrecy, and when we talk about FOIA, we talk about the lack of resources. And one of the things the students always notice when we look at the most recent set of sort of major FOIA improvements, which I think was 2012, the 2012 FOIA Improvements Act, if I'm remembering the year correctly, there are all these sort of, great new goodies and sort of additional promises, but no additional resources put to it. So that's a very big problem. Some things really come down to lack of money, lack of putting our money where our mouths are.
You and then you.
Thanks so much for this really interesting conversation. I'm curious about the question of the judicial reticence to review de novo, and maybe this is just like wildly inappropriate to the separation of powers, but I'm wondering if the kind of bifurcation between the congressional role and the judicial role could be reconceived so that the Intelligence Committee could participate in a judicial process as an intervener in some way, so that if there's a litigant who has an interest in declassifying something, the court court doesn't have to rely on their own bravery to go against deference to the executive, but instead could kind of diffuse that by having the Intelligence Committee majority have a sort of countervailing view to what the executive is expressing in that particular instance.
Maybe I'll just say briefly that Harry is one of the star students at the law school. I'm glad he's here. While that would seem to me novel and problematic, mechanism that, as I understand you, forces the congressional committee to participate in litigation. I think the closest thing that is familiar to the judicial practice already to that is the use of special masters. So judges, district court judges have broad authority right now to utilize special masters to help them understand claims or information that they can't evaluate on their own. And my first job out of law school, I was working for Senator Kennedy on his Judiciary Committee staff, and we worked on a bill called the State Secrets Protection Act, which got out of committee.
That's how we met.
Yeah, and that would have basically nudged, and in some cases, forced judges to do what they already have the power to do but don't like to do, which is use these special masters, who usually are cleared and have national security expertise. And they would fill in for that role, is the idea that they could help the judge say, this is not really a plausible claim of a national security risk, or this is overstated, or this piece could be redacted and released. So there's a milder version of reform that I think is sitting out there waiting to be.
And Carter, you worked on the USA Freedom Act, which created a cleared amicus role for some of the. Why don't you describe that?
Yeah. So for litigation in the FISA court, the FISC, the government tends to go to the court ex parte without the benefit of a defendant, a representative of a technology company, and as part of the post-Snowden reforms, Congress added an amicus to that process. Now, the court has to select that, and there were kind of rules about some clever language about when they could do so or when they might not do so. It actually got expanded in the most recent 702 authorization. And some really talented, thoughtful lawyers, former national security prosecutors, folks very knowledgeable about technology, come in and help the court. Sadly, so much of that practice is classified. But it at least is intended to provide that benefit, and that's a great idea. I saw one in the back, maybe, or two in the back.
Yes, thank you so much for your comments. Two questions. First of all, could you discuss how you see the digital revolution with a phenomenon like Julian Assange throwing a whole different narrative into this kind of situation? And the first speaker referred to Alexander Hamilton writing a Federalist paper. In the 1970s, Morton Halpern taught a class here on, in the wake of the Year of Intelligence. And he blamed it all on George Washington. He sort of said, well, the war was being conducted, and Washington had as his protege Alexander Hamilton. So here's where it all starts from. And I'm wondering what you think about that, because Washington, of course, is waging a war. He's the William Donovan of the Revolution. But he had to deal with a very difficult situation. And so it was sort of the contradictions of how to deal with this. I'm just curious what you think about that part of the Hamilton virtue issue that you talk about.
Interesting. So just on that question, on the one hand, there's no question that perhaps to the extent that Washington gave us Hamilton, who had so much influence in the drafting, and gave us sort of records like his sort of lionization of presidential secrecy, vigor, dispatch, et cetera. That certainly contributes to some of the problems we've been talking about today. And certainly our constitutional system, by creating a single presidency, by creating a president that does have these capacities, particularly as government and the executive branch grows, lays the groundwork for a lot of these problems. That said, I don't think that the actual constitutional design makes it inevitable that we have the current level of sort of worshipfulness and deference, often complete and total deference to the executive. I don't think that is an inevitable feature of the constitutional system. And so going back to Hamilton, for example, yes, he talked about the Hamiltonian virtues, vigor, secrecy, dispatch, but he was also among the sort of strongest advocates, at least in the course of writing the papers and trying to sway people to support the new Constitution, of the idea that perhaps the best feature of the president would be his accountability. He said, for example, the president will be readily watched and narrowly suspected. He also championed, for example, the Senate's role in the appointments process. He had this great line where he talked about why we don't want to make it so that executive branch subordinates are completely beholden to the president. We want there to be input from other branches. And he had this great line where he said something like, otherwise, executive branch officers will be the, quote, obsequious instruments of his pleasure, meaning of the president's pleasure. So, there's no question the constitutional framing laid the groundwork for a lot of the problems that we have today. At the same time, it's not an inevitable consequence of the Constitution itself, or even of the ideas and articulations of those ideas of folks like Hamilton.
And maybe we need a little bit more Madison and Jefferson or Lincoln, right? Of the people, by the people, for the people, rather than Hamilton's having his moment, but.
He has a whole show.
We have time for one more question, but Dave, if you want to.
Why don't we, maybe we should hear the question?
Okay. Right in front of, I think the woman in the back had her hand up first. I'm sorry, but.
Thank you very much. I was just wondering if you can tell us how do we reconcile our accountability to our people versus our accountability to our allies? So the United States does have bilateral agreements with several countries across the globe. More notably, there's the Five Eyes Intelligence Sharing Agreement, which allows for intelligence sharing between the US, Australia, New Zealand, Canada, and the UK in a more streamlined and synchronized manner. I'm doing a little research paper on this, and from my impression, it seems to require a deep level of trust, a deep level of commitment to how these nations and how the U.S. in particular safeguards, information or intelligence from our allies. And there's some, I assume, some level of entanglement with our secrets with other countries' secrets as well. So I was just wondering, how do we navigate that additional layer of challenge when we're thinking about regulating our classification regime?
Yeah, I mean, it's complicated. One of the most common claims that is made, at least in the public declarations that are submitted in these court cases, is it's not just our equities that have to be protected, it's our partners' equities. Countries will not share intelligence with us if they know that that intelligence can be produced in adversarial litigation. We have to produce it. It's a logical argument, and you heard this, in the wake of the Manning WikiLeaks disclosures of all the confidential State Department cables. And I remember Robert Gates, who was Secretary of Defense at the time, a comment that he made was leaked, where he said in an internal meeting, people are saying our allies won't cooperate with us. Nonsense. Our allies have known for decades that we can't keep secrets. They cooperate with us because it's in their interest, not because we guard their secrets. That may be extreme on the other side. I think that the difficulty is, again, not that these arguments don't have weight, but they have to be counterbalanced. As it stands, it's enough for the CIA to say any acknowledgement of an intelligence sharing with another country is a state secret, and therefore any litigation related to that has to be dismissed. And that means any time the government is cooperating with a foreign country, whatever is happening there is non-justiciable. There was quite an amusing Supreme Court case a couple of years ago. Lawyers representing Abu Zubaydah, who is still being held in Guantanamo, were trying to pursue legal proceedings in Poland, hit a wall, an evidentiary wall, and tried to get some information about the CIA's prison facility in Poland, which was public information throughout the world from CIA contractors. The CIA came in and invoked the state secrets privilege, and there was an entire Supreme Court argument, an 80-page opinion about whether the CIA could keep formally secret its relationship with Poland. I mean, this is what I would call a big Streisand effect issue. Obviously, secrecy isn't what's going on here, because the former president of Poland has said, yeah, they did it. On my watch, we had the prison here. But the majority of the Supreme Court holds that because the CIA owes this obligation to partners, in this case Poland, the state secrets invocation is proper, notwithstanding what is already publicly known. Obviously, from my perspective, that can't be the right answer, and I would recommend that everyone here read the very powerful dissent written by Justice Neil Gorsuch in this case, where he said there comes a time where we should not close our eyes as judges to what we know to be true as citizens. And says, this one at least needs to be allowed to go forward because it's making us look ridiculous to invoke secrecy here. So I'm not saying those equities aren't real and that they shouldn't be considered in deciding what becomes public or not, but they can't be absolute, or we just look silly.
I suppose just by way of wrap up, I'll say a bit on the prior question on Julian Assange briefly. I think that the rise of organizations like WikiLeaks has destabilized the equilibrium we've had for a while of very broad official secrecy, but very permissive scheme of leaking. Because in what some call the game of leaks that we've had, the players used to be repeat players. They were high-level officials and high-level journalists who went to the same dinner parties and had kind of ongoing thick relationships whereby if you burned a source, you might not get information the next time. Your publication, the Times or the Post, had internalized a lot of the establishment's values and national security concerns. And this gave some comfort, I think, to participants in the game of leaks that it wouldn't get out of hand. When you have, due to technological and other reasons, the rise of publications that don't play by those old, informal rules, then I think leaks become a lot scary to the executive branch, and that helps explain, to some extent, the uptick in enforcement that we saw in the Obama administration and since. It also, I think, suggests why the executive branch might want to rethink its current model and move toward more affirmative disclosure, given the reality of the potential for really destabilizing leaks like you might get out of a WikiLeaks going forward.
Yeah, state-sponsored cyber hacking and the ability for adversaries to obtain our secrets is also. Yeah. Well, thank you. If you join me in thanking our panel for the lively discussion and more to come.